Welcome, and thank you for joining Seyfarth's webinar, Corporate Transparency Act Essentials. All participants are in listen-only mode. You're encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. We will do our best to get to everyone's questions. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read at the end of the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to our first speaker, Robert Bodansky. Bob, you may begin.
Thank you, Joanna. My name is Bob Bodansky. I'm a partner in the Washington, D.C. office of Seyfarth and chair of the firm's institutional investor practice. On behalf of Seyfarth Shaw, it is my pleasure to welcome you to our webinar on the Transparency Act Essentials, What You Need to Know, What You Need to Do. Joining me today on the panel is Russ Robertson, a real estate partner in our Seattle office. Russ focuses on JV restructuring and formation, private placements, and debt equity financing. Susie Saxman is a corporate partner in our Chicago office. Susie is the chair of the firm's mergers and acquisitions practice. And last but not least, Michael Herbst is a corporate partner in our Seattle office. Michael focuses on corporate restructuring and formation, mergers and acquisitions, and private placement. We are part of a task force established by Seyfarth to monitor and provide guidance on the Corporate Transparency Act and the final rule issued in conjunction with the CTA. The CTA was long debated and finally passed in 2021 as part of the Thornbury National Defense Authorization Act for the fiscal year of 2021. To give you some context for our discussion, stated reason for the act is, quote, to protect the U.S. financial system from illicit use and impending malign actors from abusing illegal entities like shell companies to conceal proceeds of corrupt and criminal acts. The final rule implementing the CTA was adopted at the end of September 2022, and the CTA becomes effective January 1, 2024, just over 3 weeks from now. It is administered by the FinCEN, the Financial Crimes Enforcement Network, which resides within the Treasury Department. The focus of the Act is to require disclosure of the identities of the ultimate beneficial owners and the controlling individuals of smaller companies, together with the filing of certain personal information regarding those individuals. You'll hear this information referred to as beneficial owner information, or BOI. While this is new for the United States, similar laws have been in effect for Europe for quite some time. With that as background, our program will address who is impacted by the CTA, what the CTA requires, timing, what has to be filed and when, what information, including personally identifiable information, must be disclosed and to whom. Finally, what steps you should consider taking before the end of the year to better position your companies for compliance with the CTA. Feel free to submit questions during the program. We reserve some time at the end for questions. If we don't get to your questions, feel free to contact any of our members and any part of our task force. The names and contact information of the task force members can be found at our website, seyfarth.com. I'll now turn it over to Russ Robertson, who will discuss reporting companies and the filings that they required to make under the CTA. Russ?
Thanks, Bob. So the starting point on who is impacted and will be required to make a filing is reporting companies and what is a reporting company. So the CTA intentionally casts a very broad net and covers, unless there's an exemption, which we'll get to, all domestic and foreign companies that are created or registered through a document filed with a Secretary of State or similar office. So for domestic U.S. reporting companies, that's everything you'd expect, the corporations, LLC, limited partnerships, etc. And the CTA also captures any foreign company that's been registered to do business in the United States. Uh, Entities or ventures that don't file a document are excluded. So, sole proprietorships, general partnerships, common law trusts, those aren't covered. It's really entities formed with a state or government office. So practically speaking, this is most all entities in an organization chart for most privately held companies. And unless an exemption applies, a filing is going to be required for each and every entity, which FinCEN is estimating to be over 32 million. So this is going to be quite an event over the next 12 months. Next slide. So what are the exemptions? So the CTA currently has 23. Most of these are in areas where an entity is already going to be subject to state or federal regulation and oversight, and you can see them listed here. For example, public companies, banks, insurance companies, broker dealers, and investment advisors. These exemptions are fairly narrow. For a large number of private companies, a filing is going to be required unless you can fit squarely in one of these exemptions. Now, a couple of these I think are worth noting as maybe particularly useful. The first is a large operating company exemption, which FinCEN estimates is going to apply to more than 300,000 entities in the U.S. So it's a pretty, no pun intended, large exemption. The basic requirements for the large operating company is set forth here in the slide. You need 20 full-time employees. You need an operating physical presence in the U.S., and you must be able to demonstrate more than 5 million in annual gross receipts or sales from U.S. operations as demonstrated by your tax filings. Now, a couple tidbits to note with this: the 20 full-time employees, that can't be aggregated across affiliate entities. They all have to be housed at the entity claiming the exemption. But conversely, the 5 million in annual gross sales or receipts, that can be met through consolidated financials. A second exemption here, worth noting, the tax exempt entities. And I note with this is not merely a nonprofit corporation. You do have to have received and maintained tax exempt status. But if you do that, that is an exemption that's available. And finally, the subsidiaries of exempt entities, as folks look at their org charts and contemplate making a filing for every entity in their org chart, if you are able to claim one of these exemptions, subsidiaries that are owned and controlled by an exempt entity can also be exempt. So if that applies to your org chart, that may simplify the number of entities who you have to make a filing for. Last bullet here, just noting that, this is an ongoing compliance issue. So if you meet an exemption and lose it, you then have to make a filing within 30 days. For instance, if you are barely meeting the large company and you fall under the 20 employees, then you have to go make a filing. This isn't a one and done process. Let's go ahead and go to the next slide. So if you are a reporting company, you don't get one of the exemptions. This is kind of the basic gist of what's coming and what you have to do. So we're essentially going to have, I'd say, two buckets of entities on come January 1. We're going to have the universe of existing entities that exist at the end of the year, and then there'll be new entities formed January 1 and later. So for existing entities, you have a year to file, and you must file beneficial ownership information, which we'll get into a little more detail about what exactly that includes. For new entities, you're going to have 90 days to comply next year after formation. And now this was recently expanded. This was originally 30 days, but now it's 90 days for newly formed entities. But that extra wiggle room, I'll say, only lasts for next year. So starting on January 1, 2025, it's down to a 30-day requirement. For new entities, the main difference here between the two, other than the timeline, is new entities also have to file company applicant information, which we'll get into details of what that includes. Essentially, who's doing the filing and who's also controlling and directing the filing. So in terms of how this will be done, we don't know yet. The portal isn't open, the forms aren't available. We know that it will be through FinCEN's website, which we're waiting for them just to go live and make that available. This last bullet point, I think is pretty important to note as well, right? And relating to what I said on the previous slide, that this is not a one and done compliance filing. The CTA also requires like any changes or updates in what is filed be updated with FinCEN. So if there's a change in beneficial ownership, if there's a change in control, a director who's reported gets a new address and a new driver's license, that has to be reported to FinCEN within 30 days. So this is, like I say, a real ongoing compliance issue that'll need to be dealt with. So with that, I'll hand that over to Susie to talk about company applicants.
Great. Thanks, Russ. I'm Susie Saxman, corporate partner in the Chicago office. I'm going to talk a little bit about company applicants, and company applicants are only relevant for entities formed on and after January 1st of 2024. For all new entities that are formed, after the next couple of weeks, information on company applicants needs to be disclosed in your initial beneficial ownership interest report. Now, a company applicant, and there was a lot of discussion and maybe confusion or disagreement about what this meant when the regulations first came out. It really is going to be the individual, and this means human beings, not entities, but the human being who files the document that creates the new company. Now, if you think of an example, I get a call from a client, they need to form a new co. Let's say it's going to be a Delaware LLC, easiest entity in the world to form. If you ask me, I'm going to ask probably my paralegal, prepare a certificate. I'll take a look at it. Let's get it filed. Maybe file directly online, maybe use a service provider, CT, CSC, Cogency, whoever you might use. I'm going to be a company applicant. I directed that filing. I reviewed the certificate. My paralegal is going to be a company applicant. Likely the client who asked me to form it is as well, but you only report up to 2 company applicants on any given filing. I think one of the things we're going to be thinking about is probably who signs those certificates. I think many of us who are in the professional service business have found that often we sign those documents. It's very common for one of the lawyers or other individuals to be the initial authorized signatory or incorporator. But maybe you want to think that through, whether that makes sense. Now, accounting firms, law firms, other professionals, everybody is really, I think, going through a process of determining, what are we going to do and how are we going to handle it? My sense is that our clients hire us to form entities. We're providing legal advice. What state makes sense? What form of entity makes sense? What should the content say? I'll get it filed for you. Don't worry about it. I'll get you the certificate. There are apparently some firms that have said, well, we're not going to do filings anymore. I'm a corporate lawyer. I'd have to close up shop if I said that. I don't see that being realistic, but I think this will evolve over time as people try to figure out how best to handle this. One of the things that we know, and we're still continuing to do research, and this is also evolving, we have heard that a number of the third-party service providers are developing products that are going to help in terms of companies that are being formed after January 1st, trying to help with some platforms and services that can assist a client in going ahead and filing the BOI report with FinCEN. Next page. So let's assume that you are a company applicant. What's the information that has to be provided on the initial report, the initial BOI report? It's very straightforward. I mean, as far as I'm concerned, none of this is particularly secret. My legal name, my date of birth, my current address. As an individual and a company applicant, if I'm in the business of forming entities, I can use either my business address, my office address, or I could use my personal address. And then finally, I'm going to have to provide some sort of unique ID. I understand from some of the commentary that the driver's license is preferred. I don't think it matters really. It's a driver's license, it's a passport, it's another sort of official state form of ID if you don't have a driver's license. And then there's some other commentary in the FAQs and the compliance guide on what to do if you don't have a US identifying piece of information. So very straightforward. Next page. Now, every time you create a new entity, let's say, for example, you're setting up a new structure, you're going to create 3, 4, 5 new subsidiaries. You're going to end up being the company applicant on all of these. Every single one of them, to the extent that those entities are not exempt, so not eligible to be exempt from reporting at all, you're going to have the company applicant information in each of those filings. The alternative to providing all of that individual information to the company itself, who will handle the BOI filing, is to provide the information directly to FinCEN and obtain a FinCEN number. On January 1st, FinCEN will open its portal for the first time, and everybody who's in the business of forming companies or who is in a business that requires the formation of new companies will likely want to get a FinCEN ID number. And the value of the FinCEN ID number is if I form a company for you, instead of giving you all those other pieces of information and sending you a copy of my driver's license online, which really is sort of a hassle, I can just tell you my FinCEN identifier number. And as long as that number is linked up with me on your report, FinCEN will already have that information. They won't need to get it separately. And if, by the way, anything changes down the road about me, I will report that directly to FinCEN, and you don't have to concern yourself about it if you're the company. So initially I heard people saying, oh, I don't know who's going to get a FinCEN number, and is that like a big burden? I view it as a huge benefit. It's absolutely going to make things easier. It creates a lot more privacy in a sense, a lot less personal information flowing around the internet. And I think that for both service providers, so that might be lawyers, accountants, service companies, and for people that are, companies and businesses that are in the business of often forming new entities, I think you're going to want to have all of your folks that are involved in this process sign up and get their FinCEN identifier number. I just wish we could get it now, but we can't. We have to wait until January 1st. It'll have to be done directly on the FinCEN portal. I did learn from one of the service providers, I think I made the comment that I assume the portal will crash on Jan 1, but they indicated to me that actually they've heard that FinCEN is using an AWS platform, and it is probably much more secure and much less likely to crash, that this is really being fire tested. And so I was kind of encouraged by that. But I think in the early part of January, we're going to want to get that organized, get those numbers issued, and then be in a position between the 90 days after formation and when the BOI has to be filed to have that information all available. Michael, let me turn it over to you to talk a little bit about the required beneficial ownership information.
Okay, thank you, Susie. And hello, everyone. I'm Michael Herbst. So you've heard so far about what FinCEN is and what it's intended to do, what the Corporate Transparency Act is and what it's intended to do. And you've heard what a reporting company is and when you're supposed to file. On this slide, I'll walk through what is the information that actually needs to be submitted to FinCEN by the reporting company. So you'll see that on the left side, there's information, on the left side of the slide, there's information that needs to be reported by the company as to itself. And on the right side of the slide, there's information that has to be reported by the reporting company as to its beneficial owners. So starting on the left side, the reporting company will need to report its full legal name, any trade names or DBAs that it uses, its current address in the US, and that's its principal place of business in the US. It'll need to report its jurisdiction of formation. That's just the jurisdiction in which it filed its charter documents. Usually that would be with the Secretary of State with a particular state. For a foreign reporting company that is doing business in the US through a branch office, they would report their foreign jurisdiction of formation. And finally, the employer ID number or the taxpayer ID number for the reporting company. So all of that seems pretty straightforward and simple. Turning to the right side of the slide, the information being submitted by the reporting company as the beneficial owners. And to reiterate what has been previously mentioned, the beneficial owner is in every case an individual, right? It is never an entity. So you are going back through multiple layers of holding companies or intermediate entities to get back to the ultimate beneficial owners who own the reporting company. So having said that, the information that is going to be reported with respect to beneficial owners is the full legal name, the date of birth of the beneficial owner, the current residential address. A business address isn't going to work. It must be the residential address of the beneficial owner. And then finally, the identification number from the identification document that is being furnished by the beneficial owner. As Susie mentioned, for a company applicant, generally speaking, this is a state-issued ID, such as a driver's license, or could be a U.S. passport, if that's available. For foreign beneficial owners, they probably not going to have a U.S. passport, and they may not have a state-issued ID. So for the foreign beneficial owners, they can submit a foreign-issued passport in satisfaction of this requirement. So you're taking the identification number from that ID document and the issuing jurisdiction, and you're supplying that information to FinCEN. You're also supplying to FinCEN an image of the ID document. So that'll be an image of the face page of the passport, or an image of the driver's license, or whatever. Most of these identifying documents have a picture of the face of the individual on them. So just be aware that FinCEN in their database is actually collecting a database of pictures of people for whatever that's worth. So that's the information that would be filed on an initial report. As Russ mentioned, you're not done yet, because anytime any of this information changes, you're going to file an updated report that will be due within 30 days after the date that the reporting company becomes aware of a change. So, for example, if a beneficial owner sells his or her interest in the company, or sells his or her interest in an intermediate or holding company that holds an interest in the reporting company, then that's a change. It's going to have to be reported, and the new beneficial owner will need to report their beneficial ownership information to the reporting company, and that will be reported in an updated report. Similarly, if the president of the reporting company, her driver's license expires, she goes down to DMV, gets a new driver's license, there's a new ID on the driver's license, that's a change, and would need to be reported to FinCEN. So as you can see, this isn't rocket science, but it does require attention, it does require diligence, and it can be irksome to be chasing after all of your beneficial owners to remind them to inform you when anything that they've reported changes. As Susie mentioned, one way to streamline streamline this reporting from the point of view of the reporting company is to have the beneficial owners obtain FinCEN identifiers. The beneficial owner will get their FinCEN identifier from FinCEN in exchange for providing to FinCEN their beneficial ownership information. And then the beneficial owner would supply to the reporting company their FinCEN identifier. Any of these changes that occur to the information that pertains to that beneficial owner, the reporting company would simply have already submitted to FinCEN the FinCEN identifier and would not need to further update that beneficial owner's information. So I think everyone on the panel thinks it should at least be considered to obtain a FinCEN identifier for every beneficial owner. So I've talked about initial reports, and I've talked about FinCEN identifiers and updated reports. Before we leave the slide, I'll just say a few things about what is FinCEN going to do with all this BOI, beneficial ownership information. So under the statute, FinCEN, which is FinCEN is a part of Department of Treasury, and so under the statute, any employee of the Department of Treasury can access BOI in the course of his or her official duties, and those official duties include tax administration. Recall that another part of the Department of Treasury is the Internal Revenue Service. And none of this should be a surprise because one of the stated goals of the Corporate Transparency Act is to attack tax evasion. But the BOI that's been supplied to FinCEN can actually leave the Treasury Department under some circumstances. So a U.S. federal law enforcement, intelligence, or national security related agency is allowed to request BOI from FinCEN. Also, a state law enforcement agency is allowed to request BOI from FinCEN if they have a court order allowing them to do so. And this is interesting, a federal agency on behalf of a foreign law enforcement organization is permitted to request BOI. So here I think we're talking about a request from Scotland Yard, or a request from the International Criminal Court in The Hague, or similar bodies that are potentially able to access BOI that's been collected by FinCEN. Finally, financial institutions in the course of their customer due diligence are allowed to access FinCEN information with the consent from the reporting company. So that is a lot of information for the slide. Let's go to the next slide and talk about who are these beneficial owners that we keep talking about. So a beneficial owner can be established either through control or through ownership. So taking the first prong, anyone who exercises so-called substantial control is a beneficial owner. And that's independent from ownership. So a senior officer, that's another defined term in the regulation, of a reporting company is, by definition, a beneficial owner, even if that senior officer actually doesn't own any ownership interest in the company. Also, anyone who's got the power to appoint or remove a senior officer is also ipso facto a beneficial owner. So by a member of a board of directors, or for an LLC, a board of managers, is going to be a person who is almost certainly a beneficial owner. Again, whether or not they actually own any ownership interest or equity in the reporting company. But the regulation goes further and talks about people who make or approve major decisions for the entity. So here we move, I think, into something of a judgment call. And the judgment you're making is, well, is this person making or approving a major decision? And so I think you can look upstream and, or downstream here. So looking downstream, somebody who's maybe not typically thought of as a senior officer, but is an employee who manages a major function of the company, could end up being treated as a beneficial owner because of their substantial control, even if they don't have the title that goes with that substantial control. Similarly, you could look upstream, and an example might be somebody who's in a position of authority in a parent company who, just as a matter of fact, is extremely influential in approving major decisions of the reporting company. Again, even though they don't actually have a title that goes along with that approval authority. So there are some judgment calls to be made here that will require some thought and some consideration. Moving to the other prong of beneficial ownership, and that is the ownership of 25% or more of the entity. So for a corporation, we would be looking at either 25% of the voting power, or you would be looking at 25% of the ownership of all classes of equity securities. And that would make you a beneficial owner. If you're under 25%, then you're not a beneficial owner and not reportable. But we're talking about direct or indirect ownership here. So somebody who owns 25% or more through one or more intermediate companies in aggregate would be viewed as a beneficial owner, even though they own it through three separate entities, each of which owns 10% of the equity of the company. So it's aggregated, and it is indirect, all indirect ownership. Ownership also looks at rights to convert into ownership in the future. So warrants or options or convertible notes, if when converted, would result in the holder owning 25% or more of the entity, results in that holder becoming a beneficial owner. This is whether or not they've exercised at the time. And it's not, I think, based on a fully diluted analysis. In other words, you don't look at everyone's conversion. We just look at the person who is the holder of this particular instrument. So that, I think, sums up the question of who is a beneficial owner. Note that there is a possibility that a reporting company may not have any owners in the traditional sense. For example, a nonprofit corporation that's not tax exempt, not a tax exempt entity, would generally be a reporting company, but it doesn't have any owners. So in that case, the reporting company would be reporting under the substantial control prong, the directors, the officers, etc., but wouldn't have nothing to report on the ownership prong. Examples of that kind of entity would be an HOA or a condominium association, most of which are formed as nonprofit corporations. So I think we can move to the next slide. Criminal penalties and civil penalties. So if you decide that this is too much trouble and you don't really feel like complying, there are civil and criminal penalties for failure to comply. Willful failure to comply subjects you to criminal and civil penalties, as does willfully providing false or fraudulent beneficial ownership information. I think the word willful here is really important. My sense is, I don't think anyone knows, but my sense is that at least during an initial period, if you're making a good faith effort to comply and you incorrectly decide that you're exempt, or you get some information from a beneficial owner, it turns out not to be correct, and you submit that, that's not willful failure. And I'm guessing that as an enforcement matter, you would not generally face civil or criminal penalties.
Michael,
I'll take that.
hey, Michael,
Yes, Susie.
one of the things we discussed as part of creating your record that you haven't willfully failed to report is that to the extent you do an analysis that in which you conclude that the entity is exempt, it'd be nice to have something to memorialize that in your records on a contemporaneous basis, at least as a piece of, evidence, so to speak, that you were, trying to do the right thing. It could be that there was an inadvertent mistake, but it certainly wasn't willful.
Yeah, I completely agree, Susie. And actually, that's in my next slide.
Got it.
Thanks, Joanna. So we're, I think, at the what should we do phase of this presentation. So on this slide, I'll talk about what do we suggest what seems to make sense to us if you already have an entity and it may be a reporting company. So I think the first thing to do is to try to figure out, do I have a reporting company here, or is it exempt? That's certainly the starting point. And as Susie was saying, you may decide you are exempt. You better document that determination, memo to file, why, the basis on which you made the determination that you're exempt, or memorializing the advice you relied on in reaching the conclusion that the reporting company was exempt. And that goes back to the willfulness requirement. If you've documented what you've done and why you've done it, I think it just gets a little harder for the Department of Treasury to come after you with a hatchet saying that you willfully tried to avoid your responsibilities under the Corporate Transparency Act. So let's say you decide that you are not exempt and you are a reporting company, then you drop down to point 2 on this slide. Try to figure out who in your organization is going to have the responsibility of identifying who the beneficial owners are, and managing the collection, the storage, and the reporting of the beneficial owners' BOI. Nothing happens unless somebody is assigned responsibility for it, so it seems like that's a very logical step to take here if you think you're a reporting company. Step 3, as Bob mentioned at the very beginning of this presentation, beneficial ownership information includes personally identifiable information, BII, your address, the date of birth, etc. So it needs to be guarded safely. So it makes sense to establish some internal policies and procedures to govern the collection, the secure storage, and the reporting of BOI. And again, this policies and procedures, I think it should be in writing. I think it should be reviewed with the management team. And I think somebody should be in charge of enforcing policies and procedures. And all of that, I think, goes back to, again, the willfulness. If it turns out that you've inadvertently stepped over the line, notwithstanding your policies and procedures, it seems to me that it'll be difficult for Department of Treasury to get too aggressive with you on the willfulness side. Step 4. So having put your own house in order, you need to go out to the beneficial owners and solicit from them their beneficial ownership information, or get them to get their FinCEN identifiers, which probably is even better. So look, I mean, I think beneficial owners are not going to be thrilled with these requirements. Even beneficial owners who are inclined to cooperate may take time to gather the information and send it to you. So I think you're going to want to approach your beneficial owners as early as possible to get the process moving, so you're not in the position of making phone calls on New Year's Eve, trying to solicit information for the submission to the FinCEN portal. Step 5, collect, store, and report the information that the BOI, that the beneficial owners have supplied to you. We're talking about secure storage here, so most organizations are sophisticated enough to know how to securely store sensitive information. This is sensitive information. And finally, item 6, if any one or more of these tasks seem like they're just too much to deal with, then there are outside vendors, and more will become available as 2024 progresses, who will be available to assist you with some of these tasks. Susie, I think you had some thoughts on timing of new formations.
Thanks, Michael. I really felt strongly about this before the initial 30-day period got extended to 90 days for entities formed January 1st, 2024 and later. I mean, the idea that we would have to get filings made for new entities within 30 days put me into a panic state. Now we have 90 days, but I would suggest to people that if you think that you are going to need new entities early in 2024, consider whether it makes sense to form them now. Because at that point, you've now secured up until December 31st, 2024 to do your initial filing. Gives you more time to get your FinCEN identifiers, gets you more time to kind of get your act together within the organization, to gather information, particularly if you've got a lot of far-flung beneficial owners and you may not, in-house have some of the beneficial owner information. Just something to think about. Now, every state is a little bit different, but forming the entity before December 29th might really be forming it before December 27th. In the past couple of years, particularly during the pandemic, there were periods of time at the end of December where even Delaware, which shocked me, but even Delaware was not able to guarantee same day, next day filings for formation. And that was really problematic. Many states will expedite your filings if you pay an extra fee, but it's not true of all states, and things happen toward the end of the year that sometimes are unpredictable. So I would suggest that you really consider in the coming weeks, is it going to be a lot simpler to get those entities formed? And particularly if you want to save expediting fees, get something on file the end of this week or next week, and at least be safe that you've now got a year, and just let it sit there until your reporting obligations kick in 2024. Some other things to think about. All of these entities that are reporting entities probably have some type of governing documents, an LLC operating agreement, a stockholder agreement, other things that are out there that require or may require members or stockholders to do things relative to the company. I'm probably going to start putting into LLC agreements and stockholder agreements requirements that stockholders and members, the beneficial owners, provide information at the time they join the company as a stakeholder. And even something as simple as an employment agreement for a CEO or maybe a general counsel. You know, maybe I want to make sure I've got something in that agreement that requires them to give me this information. In fact, what probably the ideal thing to do if you want to be efficient is to say to somebody coming on, please go online to FinCEN, get your FinCEN identifier number, and give me your FinCEN identifier number. I would much rather be gathering FinCEN identifier numbers than personally identifiable information. I don't want to have to deal with that. I don't want to have to be responsible for it. I don't want to have to ask for updates when your driver's license has to be renewed and you get a new picture taken and your expiration date changes, or you move, or you change states. It's really a hassle. And for existing agreements, you would obviously have to go out and get an amendment, or you'd simply have to request information from your beneficial owners and control parties and hope that they're compliant. Sometimes in large organizations, you may have very small amount of equity outstanding where you don't even necessarily know who the beneficial owner is. Maybe you had a stockholder who died. Maybe there's something in an estate. Maybe you end up with a trust. Maybe there are trustee succession. There are just lots of details and types of information that have to be corralled. So I think if you're starting with a blank slate, and this is particularly for new entities that are being formed, starting right now, frankly, you know, get that information there. Maybe you want to have maybe you want to have an exhibit to your documents that contains this information, even if it's not shared freely with all the other members or stakeholders. So those are just some of the things that I'm thinking of. There are going to be a lot of templates. We're developing internal templates. You know, these don't have to be lengthy provisions. They can be relatively short. But I think there are going to be a lot of compliance challenges just because tracking this stuff down and having people, you know, when they say no or they don't respond, you can say, hey, section X requires you to give this to me, and maybe even it's even got a penalty for not complying. Not really sure what that would be, but you know, the ability to withhold something, you know, just be thinking about those kinds of things. Couple things that we want to do with the time remaining. First thing I do want to share with everybody, we'll probably try to share it again at the end of the program, is the CLE code, which is SS, that's as in Seyfarth Shaw, 7890, SS 7890. There are quite a number of questions that are being posted, and I think what we're going to try to do is go through a few of them. I would say that because we're presenting this webinar, we're probably 15 minutes ahead of the rest of you on this. This is all new ground. It's not like any of us learned this 10 years ago and we've studied it and there's case law and commentary and whatever. It absolutely doesn't exist. So I'm just going to try to read a couple of these things. We had some in inventory in case we didn't get any. And we also knew that we knew the answers to those. I'm going to leave those until I figure out if we're stumped. But one question is, for the large operating company exemption, does it matter if multiple entities share the same physical address? Folks on the panel, does it bother you if multiple entities are reporting the same physical address? I don't think I care about that.
Yeah, so Susie, I'll answer that question. There's actually a definition in the regulation of operating presence at a physical office in the United States. And the definition, I'll just read it. The term has an operating presence at a physical office within the United States means that an entity regularly conducts its business at a physical location in the United States that the entity owns or leases and that is physically distinct from the place of business of any other unaffiliated entity. So I think a service office kind of environment is probably not going to work. There are also, I mean, there are lots of companies these days that are completely virtual, right? And they don't have a physical office. So unless something changes in the interpretation of this regulation, those kinds of companies that are virtual or that just have a presence in a service office are not going to satisfy the requirement.
And if you're affiliated with another company, perhaps you will be able to use the same address though.
Yeah, I think that's true.
Right. How about can we confirm if you qualify for an exemption that no action is necessary? You don't need to file a BOI report to say I'm exempt.
That's correct. Yeah,
That's correct.
absolutely.
Yeah.
But that doesn't
Um,
mean you don't want to but that doesn't mean you don't want to document your determination internally.
Right.
I think that's right. I think that highlights the importance of doing that because you're not going to have a filing where you say, you know, cite the reg exemption for why you're not filing anything else. Yeah.
Also, another question posed. So I think it's posed as a statement, really a question. The requirements for new companies apply regardless of whether that entity would fall under an exemption. I think if you're exempt, whether you're existing or new.
Correct.
Correct.
I agree, Susie. Yeah, absolutely.
Great.
Well, one thing we might want to spend a minute or two on is the issue of subsidiaries and how those are treated.
Yeah,
Because-
Bob, let's talk about the large operating company or the holding company that has a number of subsidiaries. Bob, do you want to talk a little bit about how the analysis needs to be done at every single entity level?
Yeah, so if they are wholly owned subsidiaries all the way through, they can take advantage of the exemption of the ultimate parent and be fine. If it's a 70-30 split in ownership, for example, they will have to file, even if the ultimate parent is exempt, until they get to that exempt company. So if you have 3 tiers going, tier 1 reports it, tier 2 reports it, but all tier 2 has to report is that tier 3 is an exempt entity and give and that's where the analysis ends. So if it's wholly owned, you can take advantage of the exemption of the ultimate parent. If it's not wholly owned, then you go to do the analysis until you get up to the wholly owned exempt, exempt parent.
Well, a very common structure for privately held companies, maybe for companies generally, is that you've got a holding company at the top, and it does not have employees, and it does not have business operations other than the ownership of other entities, even if it is the filer of a consolidated tax return. How do you approach that analysis?
Again, you go back to the holding company isn't going to be the beneficial owner because it's not an individual. So you have to find out who owns the holding company and go through there. So from the example you gave, it does not sound like it would be exempt. It doesn't fall under any of the 23 exemptions. So if that's the case, they would have to report, and the owners of the holding company, or if the holding company is owned by entities rather than individuals, where you have to keep going up until you get to that level where there are individuals involved who are the beneficial owners.
But if the holding company owns an operating company that meets the more than 20 employees and the revenue and the U.S. address, that main operating subsidiary might be exempt. And if that operating subsidiary is exempt and it has 15 wholly owned subsidiaries, by virtue of its sole ownership and control by an exempt entity, those entities also are likely exempt and don't have to file. So in that consolidated group, in that org chart, it may be that only the holding company has to file a BOI report.
Yeah, I think that's right, but I also don't think that it's fully fixed yet from the FinCEN guidance that that's the case, that if you're above the exempt entity, what happens with your analysis? They really focus on what happens for the companies below.
So let me ask this question. I saw that there's an exemption for accounting firms. Lucky them, they lobbied FinCEN, they're exempt. Are there exemptions for law firms?
Only if you're a large operating company law firm.
Or if you're a solo and you don't have an entity formed around you, which I
Yes.
think would be pretty unusual. I think even
Yeah.
from a liability point of view, even a solo practitioner is probably going to have a PC or an LLC.
Yeah, still forming that PLLC. Yeah, there's a related question here on is there a de minimis exemption If you're a very small company with very little income, it still applies. And yeah, there's the large exemption, but there's not the exemption on the other side for limited revenue, et cetera.
Now, another question, and I say another question is, when you're looking at the 25% holders or more, the beneficial owners, are you ever reporting entities or is it always individuals?
Well, I think the information you're reporting is beneficial ownership information from a beneficial owner. So you would not be reporting information about entities ever, except the reporting company has to report information about itself.
Right. I think the goal of FinCEN is to track human beings. They are not interested in getting responses that put additional opaque entities in front of them. They want human beings. How about this question? If you form an entity before the end of 23, do you have to be concerned about qualifying to do business in other states before 23, or can you just do the qualification later? I don't think the qualification matters. It's the formation date that's really key.
I think that's right. Yeah, I think it would be the formation date. So if you do form before the end of 23, you have all of next year to do your filing, regardless of any subsequent state registrations that entity might do. I think that's right.
Yep. Now, another question, and I think this is confusing because of the recent change in the FinCEN regulations. For entities created in 2024, the information is due 90 days after formation. It's not, you don't get until 1/1/2025 if you're formed January 1st, 2024 or later.
That's right. Yeah, you'd get the 90 days. If you form on January 1, you're filing by, well, very March, April 1.
And
And
even
just
though,
a nuance on that is the 90 days runs from when the notice of formation has been received from the state,
Yes.
not when you actually do the filing.
but even though they extended to 90 days to make that initial filing for new companies that are formed, changes still only have 30 days to be reported. Does that, everybody agree with that?
That's right. Yeah, it's just for the initial filing. Yeah, that's correct.
Right.
And the 30 days also applies to if you were exempt and now you're not exempt, that when that change occurs, you've got 30 days to report it.
Right. Another very practical question, I think we talked about this yesterday. If the company applicant information needs to be updated for changes, just say, for example, your paralegal is a company applicant, but they then leave the firm, or, you lose track of them or whatever, does FinCEN need to be updated? I don't think relative to the reporting company, it matters. Once you file that company applicant information in your first filing, I think you're good. Everything else after that, if it changes for the individual company applicant, it's incumbent on them to file directly with FinCEN. It's not the reporting entity's obligation to file. Everyone agree with that?
I think that's right, Susie. Yeah, that would be my read.
How about any de minimis exception for very small entities, HOA that brings in 150,000 or a hobby business?
No, I don't think so. There is an exemption for an inactive entity, which of course is the most de minimis that you can think of. But that's actually a fairly narrow exception. The requirements, if you're inactive, if you have an inactive entity, it must have been in existence on or before January 1, 2020. So no new entities. It can't be engaged in active business, obviously. It's not owned by a foreign person. So it doesn't matter how active it is. If it's a foreign person, doesn't qualify for the inactive business exemption. It has not experienced any change in ownership in the preceding 12-month period. It has not sent or received funds in an amount greater than $1,000, either directly or through a financial account in which the entity or an affiliate of the entity had an interest in the preceding 12-month period. and does not otherwise hold any kind or type of assets. So if it owns any assets at all, it can't be an inactive entity and exempt. So it's a pretty narrow definition.
Or if it's been formed since after that date, which is long ago past. Yeah. What about trustees of, say, a typical family trust or executors of an estate? Do they have to do any filings? I view both those entities, the estate and the typical common law trust or state law trust, unless it's a statutory trust formed by the filing of a certificate with the state, those don't rise to the level of being reporting entities. Would you all agree with that?
Yes, Susie.
The entity has to be formed by filing with the state or other jurisdiction.
And that's
if you're
not true
talking,
for my family trust, that's not true. And for an estate,
Right.
that would be.
State, that's not true. Yeah, yeah.
Yeah, what about a realtor with a PLLC? Would they be exempt? What are their requirements? I assume the PLLC is going to be a reporting entity.
I think that's a reporting company without an exemption that needs to report. Yeah.
So you've got to report your 25% or greater beneficial owners and your control parties.
One thing I did want to note as well is, and folks are certainly free to email any one of us, but there is if you Google that FinCEN has put out a frequently asked questions list that they've been updating. I think the last update was about a week ago, but it also has a lot of good, helpful information in there on questions, because I know we're gonna run out of time here pretty quickly.
Right. Yeah, I think
one of the interesting things, and one of the interesting things that came up in that FAQ that came out last week was a lot of concern about when is the website going to be open, when do we get to see the forms, and they said the FAQs before your filing obligation arises was at 90 days after January 1, so that they don't make it available until March to be seen.
Yeah. One interesting company or question rather, and I think this might be the last question. I know there's some others and we'll try to get back to people individually on these. Just talking again about exempt companies, maybe describing again what a large operating company is and why is it exempt? I mean, Michael, do you want to just comment on that a little bit?
Yeah. So, I mean, go back to the whole kind of premise of this law. It's that bad actors are using shell companies to hide assets or to avoid taxes or whatever nefarious activity they're engaged in. If you have a company that is earning revenue and it's got employees and it's got a place of business, then I think FinCEN views that as more real and kind of less likely to be the kind of entity that is being used for subterfuge or obfuscation. So I think that's kind of the policy basis for the large operating company exemption. Does that answer the question?
Yeah.
I think
that's right. And one of the things that I've said to clients too, I mean, obviously this is a major sea change for us in the United States, but really we're coming much more into line with a lot of the rules and requirements of reporting that are done in countries outside of the United States. I mean, if we were part of Europe, we would have been doing this for years. I mean, the fact that we can have our list of owners can be completely private and not on the public record, which is the case, in fact, for a privately held business, is highly unusual outside of the United States. I mean, I think a Delaware LLC is one of the most private entities you can form. There's nothing significant on file.
Yeah, I've been reaching out to clients outside the US and telling them about this and expecting them to go ballistic. And in fact, it's, oh, okay, because they're already doing this, actually.
Right.
Canadian clients and UK clients and even, clients in Australia and China, they all get it.
Great. Well, Bob, why don't I turn it back over to you to just wrap things up and conclude?
Well, again, thank you very much for your time and for joining us today. Seyfarth.com, you can look for the task force. You can find all of our contact information there. We're glad to talk to you. We're glad to look at any questions you have in writing or an email. With that, I thank the panel. You did a great job, and the staff that helped us launch this. And we wish everybody a good evening, a good morning, good afternoon, depending on what time zone you're in.
Thanks, everybody. We'll get back to you with answers and comments on your questions.